Hello, my name's Stephen Labiak, and welcome to this week's discussion on things about bankruptcy. Quite often, you have one spouse that files bankruptcy and the one that doesn't. And the one that doesn't file bankruptcy always asks, I don't want to be involved. Well, at the end of the day, if they're living together, they're going to be involved a little bit. The non-filing spouse, as we shall call him or her, still has to provide their contributions to the household. That means, well, they bring in this much money, whether it be through unemployment, a job, hopefully, a small business, a large business, income, doesn't matter. Their income has to be counted towards the family income. Their other involvement is going to be their assets. So, for example, if they own a car and they acquired that car during the marriage, at least here in California, that's going to be community property. So that does need to be listed on the petition. Now, if they have some asset that they acquired through gift or through inheritance, that we can leave off. But for most people, especially people in bankruptcy, they don't have large inheritances coming in. So you need to list all the assets of both partners in the marriage, even if one of them is not filing. Another way they're involved, is, at least for California, is called a spousal waiver. That means the non-filing spouse signs a document acknowledging that the person is filing bankruptcy, and that if the non-filing spouse chooses to file in the next 8 years, they will use the same set of exemptions. What this is meant to do is to prevent a married couple from double dipping. That means one person filing, taking one set of exemptions, and then the non-filing spouse turning around and filing at a later date and getting a separate second set of exemptions, basically doubling the exemptions for a family unit. Once in a while, the government does something that makes sense, and this is just to prevent double dipping. Beyond that, the non-filing spouse is just listed one other place, just as a notification that their spouse has filed bankruptcy. If the non-filing spouse is a co-debtor, they will be listed as a co-debtor on the petition. I will tell you, as a searchable item, the non-filing spouse, it does not come up. That means when we go to the federal court system and we type in the non-filing spouse's name, their name isn't coming up. The only way to find out that they're involved is you have to physically scan the entire petition and look for their names. Now, most people aren't going to do that, and if they do, well, they probably already know a lot about you anyway, so I wouldn't worry about that. So if you're the non-filing spouse, you will be involved. You do have to provide some financial information. You do have to discuss your assets. You do have to sign one document, and your name does have to be listed if you're a co-debtor, or if you were married or are married currently to the person filing. Other than that, you're really not involved as much as you might think. So don't be afraid to answer the questions to help out your partner who is filing bankruptcy, even if you don't want them to. So if you are looking to file bankruptcy, however, and have any questions about this or anything else bankruptcy related, feel free to give me a call at 559-274-2868. Thank you.